We've been producing engaging content for the engineering community for over 3 years, interviewing industry leaders like John Hirschtick, the founder of SolidWorks, our very own engineering manager, Michael Hadley, and numerous engineers, product developers, and business professionals. But now, we want to hear from the most important people, our listeners. Click the survey link in the show notes below to share your advice and help us grow the Being an Engineer podcast. Plus, by participating, you have a chance to win an exclusive Being an Engineer t-shirt. Submissions close Tuesday, October 3rd. 5 winners will be chosen and announced in our newsletter on Wednesday, October 4th.
People should have faith in their own brilliance and really take the necessary steps to protect their ideas, because you just never know what it's going to turn into.
Hi, this is Aaron Robison with the Being an Engineer podcast. Today we're being joined by Wes Schwie. Wes is a dreamer and innovator who loves solving problems. He uses his skills as a patent attorney, engineer, entrepreneur, and business executive to bring ideas to life. Wes is the founder and a patent attorney at Gallium Law, a boutique intellectual property law firm. He's also the co-founder and general counsel at Innovelis, a company that makes innovative mounts for home electronics. Many of their products can be found in Apple stores worldwide. Wes is an animal lover and avid workout enthusiast. You can find him on his rowing machine, where he identifies as the vegan rower, riding a bike, or taking long walks in nature. In his spare time, he enjoys writing comedy sketches and jokes, which he plans to bring to the stage one day. We're excited to hear when that day is. Wes, welcome to the show.
Hey, Aaron, it's great to be here. Thanks for having me.
Yeah, glad to have you. So when we have that introduction about you, I really pulled that from LinkedIn, and it's pretty startling, or not really common, that people start with more of like why they do something as opposed to what they do. Simon Sinek talks a lot about that. And he says, start with why. You began with being a dreamer and an innovator who loves solving problems, and what you do is listed second. What made you write it in that order?
You know, I think it's really easy to kind of get lost in your occupation, identified by your job. And it just really gives people an opportunity to feel like they know you before they've really gotten to know you. And so, you know, let's be honest, when you meet someone, they say they're a lawyer, it's hard not to, instinctively develop a preconceived notion in your mind about what a lawyer is, who that person is as well. So I'd rather lead with something more based on my personality. Honestly, when people ask me what I do for a living, I usually say I work in sales.
That's interesting. Yeah, it's bad enough saying I'm an engineer, and being a lawyer might even be harder for people to look you square in the eye sometimes because of so many preconceived notions. That's good to hear.
Exactly.
So, Wes, tell us about your journey from becoming an engineer and then a patent attorney.
Yeah, so it's interesting. My journey to becoming an engineer was really based in I followed my brother, everything he did. As a kid, throughout my teenage years, whatever my older brother did, I did the same thing. He played tennis, soccer, basketball. I played tennis, soccer, and basketball. I followed him to the same high school and even the same college. And so when he decided to study engineering, it was just natural for me to do the exact same thing as him. So it wasn't until I got to college that I started to develop my own identity, really make my own path. And I guess it's funny because we both finished in engineering. He studied geoenvironmental engineering, and I did mechanical engineering. So I guess that's where our paths really started to deviate. But then my path to becoming a patent attorney is a little bit embarrassing, actually. It's, back in high school when I was like 16 or 17, I was at my friend Heather's house one day, and this guy pulls up, and he's wearing these like cool sunglasses, and he's driving this like flashy Porsche 911. And mind you, I was a teenager. I was obsessed with fast cars, and the guy turned out to be my friend's uncle. So this guy walks in the house, and the first thing I say to the guy is, I don't even ask him what his name is. I'm like, what do you do for a living? And he said he was a patent attorney. And so like from right then and there, my decision was made. I need to go into patent law. And mind you, I didn't actually go to law school until I was 32 years old. So it was, and it was for much different reasons than the guy with Porsche. But he definitely planted a seed in my mind. And I've never had a Porsche, but I do have sunglasses though. So.
Well, it's funny you share that, because I remember when I was in school, you could go to lunch with people in industry, and I thought about becoming a patent attorney, and I went to lunch with a guy who was a patent attorney, and he showed up in a Porsche 911, and he got valet parking for 2 spots down there. And I thought, maybe this is a pretty good career if you want to go after the money, but So now
That's
that you
funny.
are a patent attorney and sales and co-founder and innovator, I mean, as I know you, it seems like you're on the right path. Do you feel like, you're really, you've made a good choice and you're happy with where you are?
Yeah, definitely. The reason when you ask like, what's your why, that the Simon Sinek thing, my why is really rooted in being control and having like, maintaining a substantial level of autonomy over my day-to-day life. And I think that, being an entrepreneur, it allows me to choose, whom I work with, what I work on. When I worked as an engineer for a big corporation and also at a law firm, at someone else's law firm, I was told what to work on, whom to work with. And, the entrepreneurial world really introduced me to this idea of being a sovereign entity. You can really choose your own path and you can choose what you want to do day to day. And so that's really kind of, if you ask me what's my why, it's really just having autonomy over my own life.
Yeah. Okay. Well, let's take that then to your law firm. So it's called Gallium Law. I know gallium is a soft silvery metal and it can melt in your hand. What's the meaning behind gallium in your firm's name?
So my good friend Bill is married to a woman named Leslie. So I'm going to tell you the background of how I got the name here. But Leslie is this brilliant legal marketer. She has worked for a number of different law firms, and she knows the legal business really inside and out. And so 2 years ago, the name of the firm was Schwie Law for many years. And
Right.
2 years ago, I just decided it's time to change the name of the firm. Let's have a different name that's not so much rooted in my identity. And so I asked my friend Bill, I said, hey, would you mind mentioning this to your wife, Leslie, and see if she has any ideas for a name? And she immediately got back to me like the next day with 3 different names.
Huh.
And one of them was Gallium Law. And as soon as I saw it, I knew that was the name that we had to have. So, all these cool things about gallium having, antibacterial properties, being liquid metal room temperature, they had no bearing on me choosing the name. It was purely the optics and sound of Gallium Law that sold me.
Yeah, that's cool. It's always interesting to hear what the story is behind all of those things, right? Okay. All right. So if someone's thinking about becoming a patent attorney, what are some indicators that might suggest an engineer or an engineering student would perform better as a patent attorney than as an engineer?
People often think that creative folks stay in the engineering field and those who like to write go into patent law. And certainly I think there's some truth to that. If you want to be a writer, there's a lot more writing in patent law. But I think really if you do both and like both, you can certainly, I think either path be suited for you. I think one thing too to think about is also to indicate like what environment you prefer to work in. In engineering, I often found myself working with large groups of people from various disciplines, trying to solve these complex problems. And in patent law, there's a more solitary element of the business where, you definitely do work with inventors from the beginning where you have these inventor interviews, you really dive deep and figure out what the full invention scope is. But then there's a lot of the work is done alone on your computer where you're taking those ideas back and you're really, putting them to life in a patent application, enabling it on paper and getting it ready to file with the United States or whatever patent office you want to file in. And so I personally like both aspects of law and engineering. But I think there's certainly times when it's nice to just disappear to my office and just kind of be alone and not be around large groups. So I think one thing I'd like to always ask people is, well, think about what you see yourself doing in a couple of years and who you see yourself working with. And I think, patent law, again, you can really work from home if you want very easily. Where I think is with engineering, it's probably more inclined to being in an environment, being in the office with folks, talking things out and kind of solving problems as a large group.
Yeah, especially, or if you have, there's hardware involved and you have to be at the same location as a piece of equipment or product or something else. Okay, that's helpful. I think the idea of thinking about not just what do you want to be doing, but who do you want to be working with is a big indicator that we probably don't talk a lot about it in school. Wes, as I've known you, you've been quite generous with your time to solo inventors. What makes you so willing to offer free consults?
Well, patent law is very stringent regarding timelines, when you can. And well, you can always file a patent application if you want, but there's very strict timelines regarding, if you file too late. And so, as you know, Aaron, you can't rewind the clock. Once the time passes, you can't go back in time and say, oh, I'm going to file that patent application now. So it's super important for everyone to, make sure they're aware of these timelines and adhere to them properly. So, it's, people often think that patent applications are super expensive and, there's all these barriers to entry to getting your idea protected, but really it's not that difficult. And I should say you can make it as difficult as you want to be, but it's not that expensive. And so I'd rather talk to people up front, educate them, let them know, here's what you can and can't do. And here's the timelines to consider, and I'll let them decide accordingly. And, I'm happy to talk to anyone, anytime about their ideas and just educate them, because it's just, again, it's very important to make sure you know the timelines, because you can't rewind the clock.
Yeah, no, I've seen that about you, and it's really stood out that you just seem to have a passion about just making sure that people are protected and kind of don't make mistakes. And even if that's a little bit of your time, you're just have been really generous with it. There's a lot of misunderstandings about intellectual property, and we don't want to turn this into, law school. So what's one thing, if you could really solidify something, it could be more than one thing in people's minds about intellectual property, what would you really like them to know and understand that probably a lot of people don't understand?
So I think one thing that people, when I talk to a lot of prospective clients or inventors, there's often this general fear that, oh, if you talk to me, are you going to send me an invoice? And it's like, no, I'm happy to give you this, a free consultation. So I think the one thing is, don't be afraid to reach out and talk to an attorney and understand your rights. And I think the really important thing is it's so crucial to file a provisional patent application as early as possible. I think that's the one thing that everyone needs to understand is that, and you could do this for cheap. I mean, most inventors qualify as micro entities, and this is based on income and the previous number of patent applications you filed. But the filing fees for a provisional patent application are $60. So really, I mean, a person could, in theory, get a provisional patent application on file for $60. It's very cheap. And that's the kind of thing that I'm willing to talk to people about, is like, hey, just kind of educate them, and here's what you should include in a provisional application. Just make sure they have kind of those bullet points covered. And of course, we'll always do the work for people as well. So I think the one thing that I want people to understand is, don't be afraid to talk to an attorney, and then also to file a provisional application. Just get something on file as soon as you can.
Will you explain for the audience what filing a provisional patent application does for them, why it's so important? And really, it's pretty inexpensive, right? But why does that matter so much?
Yeah, it's a great question. So the provisional patent application establishes your date and time with the patent office, as to basically say, here's the day that my invention was, basically filed with this office. And so we call it a priority date. And so establishing that priority date as early as possible is important, because it establishes, first of all, a 12-month deadline then. So once you file that provisional application, it really gives you think of it as an insurance policy. You file this application, and it gives you then 12 months to go out and talk to customers, talk to investors, strategic business partners, make the connections you want, and feel free to, really disclose your idea. You don't want to go through and show people everything, but you can feel confident that you can discuss your idea openly, knowing that you got this provisional application on file that secures your invention with that respective patent office. And so once you file that provisional application, it again establishes a 12-month deadline. So basically, you have 12 months from that day to file what's called a non-provisional patent application. And that's the one where it's like the real serious application. It's more expensive for sure than a provisional, but that's the application that goes into queue with the patent examiner at the patent office. And it basically determines whether or not you get a patent. And so, again, I think just getting a provisional application on file, even if you disclose your idea kind of roughly, it's better than nothing at all. We have plenty of clients that have come to us, years later, after they've already released an invention to the public and sold it for a couple of years. And they're like, well, how can we now get patent protection? Yeah. And oftentimes it's difficult. You can't do it. You're just kind of stuck at that point. So hopefully that answers people's questions. And yeah, it's not as daunting a process as people really think it is.
Yeah, I mean, maybe to put it into lay terms too, right? So a provisional patent application, when you file that's when you can say patent pending, and that's probably what people see as patent pending. So a patent has not been granted, but at least it's saying to the world, hey, we're starting this, we're thinking about this. And then the non-provisional patent application, if that's granted, that's when really people say, I have a patent. Is that correct?
Yeah, exactly correct. Yep, exactly.
Okay. Yeah, so that priority date, and especially when the United States switched to first to file, it just kind of I guess, made things more clean, but also not everybody knows the importance of the provisional patent application. Well, I've been through it a few times, and you've helped us, and I've done it on my own, and it really wasn't as bad as we thought. And yeah, that year mark, and also feel a little more comfortable going out to the world and showing what you have to get some more feedback on it, we have found to be really helpful. What a little different, but it's still in regards to intellectual property. What can people do to protect themselves against counterfeit products? If they're the producer or the developer of the real products, there's a lot of counterfeits out there. What can they do for that?
Yeah, that's a great segue from the last question. So I think, again, two things. Really, it's file a provisional application, get something on file. But I think secrecy is also an important part of the game too, because, you don't want to be, the worst thing you can do is not file a patent application and then go out and talk to everyone and their brother about it, where, you tell your neighbors about it. You've got a press release you've put out there. You've got things on social media. Secrecy is really important. It's, we in the patent world, we like to think of patent applications as like submarines. These things are filed. No one knows they're there. You keep your invention a secret, and then all of a sudden it just pops up. And that's often the time when people commercialize their idea. They put it out there for a big product launch. And so I think the thing you can really do is we've got a lot of clients that sell on Amazon. And, as soon as you publicly release your idea, you're really opening yourself up to, having copycats within 3 to 6 months often. And so it's important to keep that quiet. Again, once you file a patent application, you can discuss it openly with people. But we like to tell people to discuss it with trusted colleagues, not to go out there and just blast it out there for people to see, because then again, you're opening yourself up to counterfeit products. So again, just I guess the basics are file a provisional patent application, keep things secret from people you don't trust, and until you have that big product launch or service launch or whatever it is, when you have that big splash to the marketplace.
So if you've done it correctly and you follow that process, and then you're selling your product that has a non-provisional patent application even granted, and then there still are counterfeits, what can you do?
Yeah. So what you can do is so once your patent application publishes, that establishes what are called provisional rights. And so you can essentially, even though you don't have a patent granted, so once you file a provisional patent application, then 12 months go by and you file that non-provisional patent application. 6 months after you file, it's actually 18 months after you file the provisional application, your patent application is published for the world to see. And that's the time when you can put counterfeits or infringers on notice to basically say, hey, I've got this published patent application that has these claims of my invention, and it appears that you are infringing these claims. And so basically what it's saying is, if any one of these claims that you're infringing then is patented, then you're liable for triple damages. So it's a very daunting, if you receive, provisional rights notice from a patent owner, it's often a very troubling thing to receive, because you're kind of at the point where, hey, do we keep selling this product at risk of potentially owing triple damages? Or do we just blow it off and, assume they're not going to get the patent? So it's even though you don't have a patent, you still can have a lot of power once your patent application does publish.
When you help people do that, what do you see as far as maybe the split between how often people actually do cease versus it goes to litigation?
I think litigation's kind of like the last stand. I don't think, oftentimes, and we've certainly been involved in litigation with our clients before, but I think from the number of, let's call them legal notices that have a cease and desist element to it, it's a small percentage of those that actually go to litigation. And so, it's legal notices with cease and desist elements to them are often very persuasive. Companies often just will close up shop, they apologize, and they go away. And so I think, thinking that litigation is kind of the only option you have to enforce your patent really is not the case, because you can, just by sending a letter, oftentimes that persuades people to kind of close the doors and move on.
Yeah, I guess that is encouraging to hear, that just being active and, just identifying that, hey, we don't want to litigate, but we recognize this is happening. It's good to hear that you are having some success. I find that encouraging.
Yeah, and there's a lot of these online forums too, like Amazon, Alibaba, etc. They've got very distinguished and established IP forums where you can submit complaints of IP infringement. And so it's kind of like a I don't want to call it pre-litigation. It's like sort of like a non-litigation form you can go through that. Really, it's when the infringer receives that notice of this complaint on Amazon, oftentimes the product is just taken offline then, and they've got to work it out with you to figure out if they can keep selling or not.
Yeah.
So there are a lot of non-litigation alternatives out there.
That's good to know. And probably a lot of people don't know about the spectrum of options that are available. So I hear a lot of different opinions and insights, I'll call them, as to what people think, once they have a patent, what it really offers them and what it doesn't offer them. And I don't know if I can use the right term, even protection or rights, but if somebody is granted a non-provisional patent application, what is it that really affords them as the inventor or the assignee?
Well, first of all, you're absolutely right. It definitely is rights and protection that's afforded to them. So, well, really the legal definition of what a patent gives the owner is the right to exclude others from making, using, offering for sale, selling, or importing that idea into that country, wherever the patent application or the patent is issued. So you're probably thinking like, man, oh man, what on earth does that mean? Like, you've got the right to exclude, but you don't have the right to practice your idea, which is kind of confusing to people. So the really important thing to know here is that, again, a patent does not give you the right to make or use your invention, but it gives you the right to stop others from making or using your invention. And so hopefully it didn't confuse you more, but I'll give you kind of a patent 101 lesson. So here, hopefully this doesn't confuse people too much, but so let's say a patent claims a device comprising A, B, and C. So basically when the word comprising means that patent it covers A, B, and C and anything else in addition to A, B, and C. So let's say someone has a device that they're selling that's got A, B, C, D, E, and F. Well, you're infringing the patent that has the claim for A, B, C. But you could potentially get a patent for your device that has A, B, C, D, E, and F. But again, you can't practice it because the previous claim for A, B, and C. And so in that situation, you'd probably want to go to the owner of the ABC patent, try to get a license, maybe see when the patent expires. It might expire in a year or two, and you can just kind of wait. But the important thing to note here is, again, it doesn't give you the right to make or use your invention. It gives you the right to exclude others from making or using your invention.
Yeah, it's an interesting model that people are granted rights to exclude others, but the right to produce or sell, et cetera, that's really is it really through the legal mechanism and contracts, et cetera?
Yeah, exactly. So again, if by getting a license, you can, you're basically getting the rights to use the ABC patent. And by having your patent for ABCDF, you effectively have control and you can sell and make and use your own invention because you have the rights to the ABC, which is again through a contract or a license. And then you've got your own patent for ABCDEF. So, and you can then if you could then thereby license your ABCDEF patent to someone else then too, if you want to go out and draft a contract, license it, monetize it, make passive income. So a lot of it is done through having contracts with various entities that want access to, your intellectual property.
Yeah, that's really helpful. Hopefully that helps the listeners understand a little bit more maybe than where they were. They should certainly reach out to others. If someone does want to find, everyone kind of knows someone that's a patent attorney or knows someone that knows someone. What are some of the things that you recommend people screen for to make sure that their patent attorney is really going to be a good fit for them or, a good patent attorney?
Well, I like to ask, what's their experience? And well, first of all, I think cost is one issue or one thing I like to ask about. And then also just, make sure you understand what their background is. Do they have patents themselves? Have they enforced patents? Have their patents been through a litigation? They've been tested by other parties. And so, oftentimes we've had plenty of clients that have come to us and they've worked with a different attorney who drafted an application for really cheap. And then it comes to us and we're, we've got to prosecute that or, work with the patent examiner during the examination process. And there's so many issues you encounter that it's oftentimes a lot more expensive on the back end to fix these things than it is in front end. And sometimes it's just fatal too. You just can't fix some of these issues. And so I think some of these things that, inventors might be enamored by is someone that has like a cheap patent process where they they can do a patent for $1,000 or, whatever it might be. And those are things where I think when I hear that kind of stuff and it's all about cost, it's immediate red flags for me. And so I think at that point, you want to really ask that practitioner, okay, well, tell me about your experience. Have you had patents that have been tested in, an ex parte re-exam or an inter partes review or in various, litigation forums? Have your patents been tested and have they withstood? And so I think that's, you really want to make sure you know the history of your patent lawyer you might work with, and not focus on things like cost, but really understand their experience.
That's helpful. Yeah. Pay me now, pay me later type of thing, or you might not even be able to fix it later. So that being said, what are some of maybe I'll say the range of costs that people should, generally expect for a provisional patent application and a non-provisional patent application?
Yeah, great question. So so I'll speak on our experience, what we charge clients. And so we really have an open model with clients where, I don't want to see people not get a patent based on cost. I'd rather have you at least come to me, talk to me. I can coach you through the process and we can kind of figure out, okay, is there some budget we can work with? And we've done, so to give you kind of a range of patent fees you might encounter with us. And this is, I think, very typical of the industry too. But typically let's say for a non-provisional patent application, we often we cap our fees at $9,000 for most applications. And so I think typically most non-provisional patent applications are in the range of like $7,000 to $9,000. And some people might think, well, hey, I don't have $9,000, I can't get this thing patented. We do work with clients, and we've worked with clients for much smaller budgets where it's like literally a few $1,000s. So if a client comes to us and says, hey, look, can you help me out here? Can we, get an application on file for a couple $1,000s? We can definitely help you, because I'm not going to turn away someone that has a legitimate need for intellectual property and wants to protect their idea and have money be the issue. So, but that said, we've also done, larger scale omnibus patent applications, which cost literally tens of thousands of dollars, where you're trying to protect a lot of different features of complicated systems. So I guess at the end of the day, really the range is very, very open. But I think, for a non-provisional application, I think about $7,000 to $9,000 is a good range. And then provisionals are cheaper than that because you're just not doing as much. And so hopefully that gives our listeners an idea of what to expect in the patent process.
That's really helpful. At least to give some people some ideas. And, that's not a zero expense, but for a business expense and what it hopefully gets you, that's good and hopefully makes it a little less daunting for some people out there listening. So before we change gears out of intellectual property and more of the sort of the personal life, anything else you'd like to share for the listeners around intellectual property?
I think one thing, people often, I often tell people about is you just never know what your invention might turn into. And so I think it's important to, again, just talk to someone first before you decide on what to do. But here's a story I can give you, and it's a real boneheaded story about my own experience. It's a real doozy. But so before I went to law school, I had this idea, and my idea was this was when smartphones first came out. And so it was for a smartphone case with a credit card slot in the back. And so I thought, oh, this is a cool idea. I mean, I'd love to have my wallet, which was basically a few credit cards and a few dollar bills, kind of merged into my phone. So it's all in one. And so I even began working on the provisional patent application, but I never filed it. And so when I was working with Innovelis, years ago, I ended up going to CES, which is the Consumer Electronics Show in Las Vegas. And I was there, and this is over a year after I drafted this application, kind of let it just, didn't do anything with it. But I saw that this company had smartphone cases with credit card slots in the back. And I was just like, it's like that hand slap on the forehead, when you're like, oh man, like, what did I do? And so I think it's just, the notion here is that people should have faith in their own brilliance and really take the necessary steps to protect their ideas, because you just never know what it's going to turn into.
Yeah, well, what an experience there. And especially the idea that you even started drafting it. I think most people will say, oh, I thought about it, but didn't get so far as even drafting it. What a story. Well, at least you can laugh about it and tell the story now.
Yeah.
So let's get away from intellectual property for a little bit and more on the personal side. That's what really makes you up, and that's what you even led with. What is it, Wes, that brings you joy, or what are some of the things that bring you joy?
I think smiling and laughter really bring me joy. So seeing or hearing people laughing around me, laughing myself brings me joy. Hearing something just kind of silly off the wall. I just love to laugh at bad jokes. And so can I actually tell you a joke?
Oh, please. Yeah.
Okay. So it's funny coming from a vegan, I'm going to tell a hunting joke. So there's 3 statisticians go duck hunting. So they all head down to the lake and they get set up. And just then they see a duck take off from the lake and fly away. And so the first statistician jumps up and shoots, boom, but she misses right by 3 meters. So the second statistician jumps up and shoots, boom, they miss left by 3 meters. And the third statistician jumps up and he shouts, yes, we got him. So hopefully I'm bringing you some joy.
That's perfect. Yeah, and it's one of those things that not everybody would get, but it's tailored to the audience, and this is probably a pretty good audience for it. I'll try that one at home tonight and see which one of my kids gets that one. It'll be a test.
Excellent. Well, I look forward to hearing back.
Yeah. Did you come up with that one?
No. Actually, my fiance's cousin told me that joke, and I was just, I feel like whenever I tell a joke, sometimes I butcher it because I get too excited for the punchline. This is one joke that just stuck with me, and I love this joke. So
that's really good. Thanks for sharing. So you say that you enjoy writing comedy sketches and jokes. Don't make any big reveals, but what are the types of comedy sketches and jokes you like to write? I mean, is it like the one you just told us, or a little different flavor, or what?
So I like to write, I really like SNL. Saturday Night Live I've been a big fan of that show for a long, long time. And so, I find myself watching the show, and, this last year it wasn't as good as previous years. And so I found myself critiquing it really a little bit too much in depth. And so, but a lot of my sketches and a lot of my jokes are more sketches where it's like, it's setting up a sketch for an SNL type cast where it would be performed by, a couple actors, and there'd be a background, whatever. So, a lot of my jokes are more just like these ridiculous sketches I think would work well in SNL.
Well, hey, we're excited to see some of those come live sometime through whatever means you do it. So you have to let us know. Great.
Absolutely.
Maybe not on the joyful side, but how about on productivity? Do you have any routines or habits that really help you stay productive, or I'll even say healthy as well?
Absolutely. So yoga and exercise are the 2 things that I really have to do every day. I do some form of exercise. I recently just bought a tonal, and I've been doing that like every other day. I was a rower in college, and so now I don't row on the water anymore, but I've got a rowing machine in my basement. It's a Concept 2 rower that I use. And so they've got Concept 2 post these workout of the days that, so you just log in, they've got a workout post and you just do the workout. So, I often start my day with yoga, and then I try to find time at some point during the day to kind of disappear for, half hour, and get on the tonal or do rowing or whatever. And then just walking too, trying to incorporate walking into whatever. Walk into the coffee shop or walk into a local restaurant or the library, just make sure I'm getting plenty of exercise. That's just really kind of makes me feel productive. And it's just a routine that I have to stay in to keep those endorphins moving.
Well, I don't know if others can pick up on it, but I feel like I can almost hear the goodness in that, in the tone of your voice where, you're sharp on when it comes to work, but at the same time, you like to laugh and have fun, and you just don't seem to be insanely stressed out. I'm sure, being in those companies and what you do is difficult, but it sounds like what you're doing is working from what we can tell on audio.
I appreciate that. I'm glad it comes through, because I think definitely yoga is something that really kind of calms me down. And like if you have a stressful day at work, it's like if you just disappear and do some yoga, it really calms you and just kind of recenters you. So I definitely have to do that, because being a lawyer can be very stressful, but you got to find outlets to relieve the stress. Yeah,
well, that's good for you. I'm a rock climber, and I climb typically indoors at a gym, and it's often the case that they have yoga as well. And I've always wanted to do more of it. I've only done a little bit of it, and it's just one of these things of, hey, let's prioritize and bring it in as well. So we'll have to give that a try. Well, Wes, that's pretty much it. We really appreciate your time. If folks would like to get in touch with you, how would you like them to reach out to you?
Yeah, I appreciate that. So I think 2 ways. Typically, email is best for me. I can give my email address here, and I'll spell it too so it's Wes at galliumlaw.com. So it's WES at GALLIUMLAW.com. or through our website, and it's just www.galliumlaw.com. So I think those are the best ways. I'm not on social media. I've got LinkedIn, but I don't, check it a whole lot. So I think email is probably the best way to go.
Maybe you could have listed that too as one of the ways to stay healthy. I don't know. Personal opinion though.
Yeah,
right.
For sure.
Wes, well, thank you for your time. Glad to have you on the show.
Hey, thanks, Ladder, and really appreciate it. Have a great day.
I'm Aaron Monker, founder of Pipeline Design and Engineering. If you liked what you heard today, please share the episode. To learn how your team can leverage our team's expertise developing turnkey equipment, custom fixtures, and automated machines, and with product design, visit us at teampipeline.us. Thanks for listening.